ASL interpreter. All right. There it is. Okay. The January 30th meeting of the Commission on the Law Revision Commission will come to order. Can you call the roll to establish a quorum?
Sure.
What? Oh, it's on. Are you there? That work? Not close enough. Okay. I should know that. Okay. We call the roll to establish a quorum?
Sure. Commissioner B,
Present.
Commissioner Carrillo,
Present.
Commissioner Kubas.
Present.
We did have an announcement that we didn't quite make yet.
Oh, that,
About
yes.
Senator Blakespear.
Yeah, Senator Blakespear has stepped down from the commission. The Senate has appointed Senator Eloise Gomez Reyes to replace her, but I don't believe that Senator Reyes will be
That's
with us-
correct.
with us
Yeah,
today.
so I'm not going to call her name. She
Right.
was not. She was recently appointed and unable to attend today. Commissioner Hebner,
Present.
Couldn't hear you, but he's present. He said present.
okay. Commissioner Jenkins.
Here.
Commissioner King indicated that he will join us this afternoon. And Assemblymember Pacheco indicated that she was going to attend, but I do not see her
Yeah,
yet. Okay. And Commissioner Simpson.
here. Okay, quorum is present. I'd like to remind commissioners and speakers, please ensure that you turn your mic on, speak directly into the microphone. I'm reminding myself, of course, so that you can be heard by the teleconference participants and those here and for the meeting. Also, for those appearing remotely, it requires that you to be visible on camera, so keep that in mind. We mentioned the Senator Reyes will be replacing Senator Blakespear. I also want to welcome, is it Yanan? Yan? Is an extern from UC Law School in San Francisco, and wonderful to have you with the commission, and welcome. I think as we sent out, we will not be adjourning to closed session this morning. So the first item of business is the minutes of the meeting of the December 4th meeting.
I move to adopt the minutes.
There's a motion. Is there a second?
Second.
So is there a second? Is there any questions or comments or modifications from members? Hearing none, seeing none. Any public comment? Hearing none, seeing none. Can you?
So we have a
we
motion
have
and
we have a
second.
it's been moved and seconded.
Okay, I could go ahead and call the roll on this. Commissioner B,
Aye.
Commissioner Carrillo,
Aye.
Commissioner Kubas,
Aye.
Commissioner Hebner,
Aye.
Commissioner Jenkins.
Aye.
I still do not see Assemblymember Pacheco, so Commissioner Simpson.
Aye. Motion's approved. Item 2, administrative matters, report of the executive director.
Sure. Let me just get back to my notes. Bear with me for a second. Too much paper here. We continue to monitor our budget. It looks like everything's fine. And I would also like to thank Commissioner Jenkins and her staff for continuing to help Christy, our chief of administration, in establishing a budget tracking system that we think better meets our needs. So that's been an ongoing process, and we definitely appreciate it. We are continuing to look for office space. We've now contracted with DJS, so they have the specifications. Apparently, it can take quite some time. We're totally open to maybe moving into something that is already built out, which would save us time. We've been steadily working on that. We are continuing, we haven't entered a contract yet for our website, but I know that's something that Christy has been looking into and making sure we're following all the appropriate state contracting rules on that. So hopefully we'll be able to report on something on that soon. And then I'm also happy to say that we were able to advertise the vacant Attorney 3 position. And we have applications, and we're hoping that we'll have an announcement at the next meeting about hopefully somebody joining our staff.
Oh, that'd be great. Yeah. Okay.
Are there any
Any other-
questions?
Questions or comments from members? Hearing none. Commissioner suggestions. Are there any new study topics, discussion of our process, general matters that that commissioners would like to raise? Yeah.
Yes,
Yeah,
I
Anna.
had brought up last time the calendar of our meetings to look into the Labor Day one that Friday. I wonder if we decided on changing that, deleting it. Do you remember that?
That's actually the next item on our
Oh, it
agenda.
is.
Yeah.
So
There's
I
a little
will
memo
hold
on it.
off
So
until then. Thank
We
you.
anticipated your
Isn't that
your
great?
insight. Yes.
I'll hold
Okay.
off.
Okay, so any other commissioner suggestions or comments? Seeing none. Before we get to the meeting schedule, new proposed topic for our resolution of authority.
Mr. Chair,
Sure, so
Yeah.
I just want to know for the record, this one's my fault.
What? This wasn't your
Th-
fault?
This is my fault.
Oh, this is your fault.
Yeah,
Uh-huh.
so I'll let Sharon introduce it and then I can answer questions.
Okay.
I would really appreciate it. This was my first somewhat deep dive into writ practice, so any assistance that you could provide would be greatly appreciated. So this new topic was submitted by Commissioner Carrillo on behalf of Justice Daniel Bromberg of the 6th District Court of Appeal. Writ practice is a pretty complicated thing to understand. I will do my best to explain it to you. Just to set the groundworks is a writ is a directive from an appellate court to a trial court, an administrative agency, or a person to do something or to stop doing something. And so a writ is available when the ordinary appeals process is not available. So they are heard as a matter of discretion and are governed by equitable principles. An appellate court generally will grant writ relief only when the petitioner has no other plain, speedy, and adequate remedy in the ordinary course of law and will suffer irreparable injury if such relief is not granted. A party to an action may file a petition for a writ, and the California Rules of Court have a detailed procedures on exactly how to do that, and some guidance actually even for a layperson how they might do that. The Justice Bromberg cited to a commission report that was published in 1997. So writs are something that this commission has looked at before, and in fact, there were a series of background reports prepared by Professor Michael Asimov that we can look to in understanding the process. There were actually 7 background reports. So civil writ practice is generally governed by the Code of Civil Procedure and the rules of court that are adopted by the Judicial Council. So the first section, section 1068 of the Code of Civil Procedure, provides for a review to correct a completed judicial act in excess of jurisdiction, in excess of the court's jurisdiction. Section 1085 provides for a writ of mandamus to correct an abuse of discretion or compel the performance of a ministerial duty. And then sections 1102 and 1103 provide for a writ of prohibition to prevent a threatened judicial act in excess of jurisdiction. So Justice Bromberg writes that he believes the writ practice is poorly understood, inefficient, and unevenly applied. And he believes that a study by the commission could point to how it could be improved. And he also explains in more detail how writ practice works. He does note that it's poorly understood. There aren't that many governing statutes to look to, and they are generally granted or denied without explanation, so there isn't that much case law on them. So appellate courts have broad discretion, which I think I already mentioned, and each division in the Court of Appeal has its own writ staff, and writ practice varies across the state. And the other point he makes is that few lawyers file writs frequently, and even fewer do so in multiple venues. So that leads to it makes it challenging for the lawyers because the writ practice isn't well understood by practitioners. And then as far as his concern that writ practice is inefficient and wasteful, he actually points to some statistics by the Judicial Council. And the Judicial Council 2025 statistic reports that in 2024, over 5,000 petitions were filed, but very few are granted. And there also are a large portion of filings that are weak or frivolous, from unsophisticated and often vexatious litigants. And for those who don't know what vexation litigants means, it's persons who will file legal actions that routinely that don't really have a basis for being filed, but still require the court's time and attention. So he also points out that because appellate justices rely heavily on writ staff, there is an even application throughout the state. So that could be another thing to look at. Maybe there could be more guidance for the courts on how to deal with the writs. And then he points to, as an example, that federal courts are able to avoid some of these problems, and he details more in his memo, which is attached, but he notes that in federal courts, writs of mandamus are subject to a stringent additional requirement that the right to relief is clear and indisputable. So in closing, he's urging the commission to conduct a study of how the writ practice could be improved. He did cite to a couple other areas in writ practice that might warrant review, but this memo is just focused on the issue that he brought to the attention of the commission. Writs of habeas corpus, for example, would probably most likely be within the jurisdiction of the Penal Code Revision Commission. So the staff believes that this is worthy of study, and to be able to do so, it would need to be added to the commission's resolution of authority, which will be presented to the legislature this year. There would still be time to add this new topic if the commission is interested in pursuing this topic. So the question is, would the commission approve of staff requesting the legislature to add this new topic to the commission's study authority? And now I'm going to turn it over to Commissioner Carrillo to see if he has anything to clarify or correct.
Well, Commissioner Hebner had his hand raised.
Oh, I'm sorry.
Oh, no. Commissioner Carrillo's hand was up first. I was just waiting in line.
Oh, okay, got it.
So, thank you for considering this issue. I'm in the small group of California practitioners who have done a lot of writs. It was a substantial part of my practice for around 10 or 15 years. And I can tell you it was a very painful experience developing expertise in this area. And I echo Justice Bromberg's impression that outside of people who do them a lot, they're very poorly understood. And that includes the bench. So my practice extended statewide, and I encountered significant variation in how each writ was treated and how each writ was treated in different counties. Depended on what court you were in, it depended on what kind of writ, it depended on what agency you were taking the writ from, if it was an administrative mandamus matter. And just the fundamental distinction between the traditional writ and the writ of administrative mandamus, that was also poorly understood, to the point that there's a published California Court of Appeal case that says that it doesn't matter if you denominate the name of the writ incorrectly, we'll just consider that you meant the correct one and move on from there. That's how bad it is. So in discussion about this with my friend, Justice Bromberg, he felt that judges across the state would be profoundly grateful if there were a legislative solution imposing uniform standards of procedure and practice in this area. And that all starts with the commission getting this into its study topics approval. So I'm happy to answer questions. I definitely don't want to torment you with a deep dive explanation on the difference between traditional writs and administrative mandamus, why they're treated as law in motion sometimes, why you have to go to a master calendar department sometimes, what difference that makes. It's a long explanation. I'm happy to go into it, but I'm not sure I need to. The top level here is that it's an extremely obscure and opaque area of civil procedure that actually comes up fairly regularly in the trial courts. So even though most attorneys wouldn't know one writ from the other, as Justice Bromberg pointed out, there are literally thousands of these that get filed every year. And so judges across the state have to deal with them. And they typically are brought by people who aren't very experienced. And the judges themselves have difficulty figuring out what the rules are. So clarifying this area of procedural law would be a great boon to the trial courts if this were approved.
Commissioner Huebner.
And my comment is a strong.
Maybe a little closer to the mic.
My comment is a strong endorsement of us proceeding to get authority to study this, largely because of the efficiency benefits for the court system, which is already overstressed. So I think this is potentially a very impactful project. My only concern would be drifting into the habeas corpus writs, but it sounds like would be under another body's jurisdiction anyway.
Okay. Other comments from other commissioners? Yeah, Commissioner B.
I'm supportive of staff looking into this issue, because it's an important issue, but also because they said they had the bandwidth to do it, because that would have been my only
Right.
concern.
Right. Okay. Not being a lawyer, is a writ something? It looked like in the description that it's something to try to fix a previous judicial action.
It can be. That's one version of it. So the traditional writ is usually brought in a higher court to fix something, as you said, that the lower court either did incorrectly or didn't do at all. So
Okay.
the writ of mandate is to require something. The writ of prohibition is to bar something. The writ of certiorari it's effectively a writ of review. So yeah, that's one context where it can arise. The other significant context that it can arise is in the administrative decision review context. So one thing that didn't get unpacked in the memo is Code of Civil Procedure section 1094.5, the writ of administrative mandamus. It's very commonly used to review things like DMV license suspensions. California has something called the Administrative Procedure Act, and there's a
Mhm.
federal analog to that.
Mhm.
So not any, but most state agencies are subject to the APA. And so if the agency makes a decision that falls under the APA's review provisions, the way you seek appeal or review of that agency decision, suspending your license or whatever, is through the writ of administrative mandamus to a superior court judge.
Oh, interesting. Okay. So this is an issue writ large, I guess.
It is, not to make a pun.
And the other question I had is this the um, fixing whatever's wrong with the writ process? Is that something that the legislature would do by statute, or is that something that the courts would do through the court, like the Judicial Council and the Supreme Court process? The appeal
Much of it
process?
could be done through statute by clarifying the problem is that there aren't clear procedures for specifically for the traditional writ 1094.5 administrative mandamus writs. They have some procedures built into the Code of Civil Procedure. The traditional writ has almost nothing.
Mhm.
And so you run into situations where, for example, if you're trying to seek review of the decision of a local administrative body, like, I don't know, the Parks and Recs Commission in San Francisco, if they deny you a
Okay.
permit for something,
Mhm.
The San Francisco code may have procedures for how you seek review of that. They may not. That would be super helpful if that were standard across the state. Some local agencies will adopt the state APA, but not all of them do. In that case, there's effectively no procedures. That could be codified in statute, particularly for general law cities. It's a little bit different for charter cities, but much of this could be accomplished by statute. And I would bet that if there were statutory changes in this area on a wholesale basis, I strongly suspect the Judicial Council would pick up the ball and make whatever tailoring changes they need to make to the rules of court.
Interesting. Okay.
I'll second that on the Judicial Council. Being a former Judicial Council employee, I'm sure they would go to their advisory committees and have them do a deep dive and change any existing rules of court and other information if something is passed.
Right. This is even something that potentially can be coordinated. Like as Sharon said, the Judicial Council pays attention. So if the legislature moves on something like this, it's not going to escape their notice.
Right. Right. Okay.
Yeah, absolutely. As part of our outreach, we're always reaching out to affected agencies, or in this case, another branch of government. So that would be our process. And I think we would also want to reach out to practitioners, the relevant sections of the California State Bar, and make sure
Yeah.
it's well advertised so we get really good public input.
Okay. Any other comments or questions from commissioners? Hearing none, seeing none. Any public comment? Anyone from the public wants to weigh in on this issue writ large? Bump. Hearing none, seeing none. Is there a motion to approve this addition to our resolution of authority?
Since I've taken blame and responsibility for this, I will move the memo.
Okay. Is there a second?
Second.
It's been moved and seconded. Will you call the roll?
Sure. Commissioner B,
Aye.
Commissioner Carrillo,
Aye.
Commissioner Kubas,
Aye.
Commissioner Hebner,
Aye.
Commissioner Jenkins,
Aye.
and Commissioner Simpson.
Aye. Okay, well, thank you. We get to learn some interesting new stuff. Okay, next item under administrative matters is meeting schedule. Sharon?
Yes, so at our last meeting, it was pointed out to the staff that we had proposed a date that was on the Friday of Labor Day weekend. So we were directed to come back with you with an alternative date. And so we looked at the calendar and are suggesting that the meeting could be moved to September 11th, 2026, or alternatively, that no meeting, we could just not have a September meeting. The last day of the 25-26 legislative session is August 31st, 2026.
Hmm.
And so we wouldn't be responding to any legislative inquiries. So it's really up to the commission on how you would like to proceed.
Any comments or suggestions from commissioners? Commissioner Hebner, are you?
No, that's me, the other David.
Oh.
Or did you have your hand up too?
No.
Oh, I don't know.
Okay.
Oh, yeah, okay. I thought- Raising your hand, sorry. Yeah. David?
For what it's worth, I agree with Sharon. I suggest that we forego our September meeting.
Second, I agree.
Is there any disagreement with that?
Are there any concerns from staff?
Any concerns from staff?
No, no. I mean, projecting out the calendar, we think that works. And in the event that something came up, we could always
Schedule.
reach back out to the commission
Schedule
and
it.
say, we really need
Yeah.
to schedule a meeting. So
Okay. Any public comment? Hearing none, seeing none. Shall we then, do we need to vote on
sure.
that? Okay. This would be to drop the meeting that is currently scheduled for September 4th, correct?
Correct.
Okay. All right.
And so I will call the roll now. Commissioner B,
Aye.
Commissioner Carrillo,
Aye.
Commissioner Kubas,
Aye.
Commissioner Hebner,
Aye.
Commissioner Jenkins,
Aye.
and Commissioner Simpson.
Aye. All right. I just took it off my calendar. Okay, 2026 legislative program.
Sure, this is the memo that you all see very frequently about what is in store legislatively for the commission. Before I get into that, though, I just wanted to give a brief update from Dan Robbins and the Uniform Law Revision Commission. He was unable to attend today, but he wanted me to share the good news from him on his behalf. And so that relates to SB 25, the Uniform Law Revision Commission's pre-merger notification bill. And just to remind everybody, the bill requires a person who is obligated to file a notification pursuant to the federal Hart-Scott-Rodino Antitrust Improvement Act of 1976 to file a copy of that form and any additional documentation with the Attorney General if the certain requirements are met, and it would prohibit the Attorney General from disclosing the information received with limited exceptions, and authorize the Attorney General to impose a civil penalty for a violation of the filing requirement. As you may recall, I think towards the end of last year, the first year of the legislative session, SB 25 stalled because there were some concerns. So it did not move forward last year. In the meantime, my understanding that Dan, on behalf of the Uniform Law Commission, was busy negotiating with persons who had concerns and working with the author's office. They did come to some resolution to address their concerns. And the assembly, it passed the assembly, and it is now in the Senate for concurrence and the amendments that were made in the assembly.
My recollection is, I think I looked at the history, it was a unanimous vote in the assembly, if I remember correctly.
I believe so.
Yeah, okay.
Okay, did anybody have any questions about that?
Any questions? Seeing none, and then,
Okay, so getting into the
right.
the actual memo. So we're pleased to announce that Assemblymember Pacheco, who is also chair of Assembly Rules and a commissioner, has agreed to carry the commission's resolution of authority the staff is very grateful to Assembly Member Pacheco and her staff for the assistance. I think you all are very familiar with the process for getting this authority, which we're required to do this every once per 2-year legislative session. The memorandum sets forth everything that we are requesting that would be in the resolution. As you recall, the commission did approve adding something related to the education code and the code of civil procedure. The commission just approved the new topic relating to writs, so we'll need to, I think that would fall under the code of civil procedure, so that is listed on 3. So that would be included in the resolution. Any questions so far? Okay, the state and local agency access to customer information from communication services providers. As you know, the commission had approved a final recommendation on that one. We have been in discussion with a legislative member about carrying the legislation to implement this recommendation in 2026. And just in terms of the legislative calendar, the Office of Legislative Counsel had a deadline by which bill drafts had to be submitted to the office for introduction later. And we do have, in all of the proposed legislation I'm going to discuss, we do have drafts into Legislative Council. So we're in good shape there. We just we can't announce who the members will be at this point. The Equal Rights Amendment, that study was also approved for a final recommendation. Senator Blakespear had initially indicated that she was going to carry it. Unfortunately, it looks like that's not going to work out for her bill package this year. She also shared some information, or her staff also shared some information with us related to what they've been hearing about the proposal. We just found out about this recently, so we haven't had time to explore it, but we will be exploring. We will be reaching out to folks to see what they have to say about the proposal. I think it's information that we hadn't previously heard. We are grateful that for Senator Blakespear's assistance. Like I said, we do have the bill draft into Legislative Council, and we will keep you apprised of the status of this one as it moves along. And then finally, antitrust law, single firm conduct. The final recommendation will be considered, the staff draft final recommendation will be considered at the meeting today. In anticipation that it may be approved, the staff has been in discussions with the legislative member about carrying legislation in 2026. We will keep you apprised of how all that is going. And again, we do have a draft into Legislative Council. Are there any questions?
I just had a quick question. The biennial resolution of authority, if that's an concurrent resolution adopted this year, is that applicable to 2026, or is that for the 27-28 session?
I think it would be applicable once it passes. So I think our last resolution passed in the spring of the year it was introduced.
Mm-hmm.
So yeah, that's a good question. So for the new topics, we wouldn't have authority until the resolution was passed.
Right. But would that authority extend into the next legislative session?
Yes.
It will.
Yes.
Okay.
Yes.
Okay. Are there any questions or comments from members? Hearing none, seeing none. Any comments from the public? Doesn't look like it. Okay, and I don't think there's any vote required
No vote
for
needed.
this? Okay, thank you. Next item, the annual report.
Good, good morning, everyone. I'm presenting this memorandum 2026-5. The memorandum presents a staff draft of the commission.
Steve, I'm so sorry to interrupt you.
Close.
Can you lean a little closer to the
Sorry.
microphone? Thank you.
All right, let's
There you go.
better. Okay, thank you. Really needs to be clear.
Yeah, I'm having the same problem.
All right. The memorandum presents a staff draft of the commission's 2025-26 annual report. And one of the appendices for the commission's approval, the annual report is required to be prepared by the commission's governing statute, and it, once finalized, goes into our bound volumes that are distributed to all libraries generally. Each report there's a lot of language which is similar, but there are some items which require specific attention by the commission, and those are shaded in the draft. And those are on pages 3 and then 10 through 12. To save you some time, what's on page 3 is duplicated on page 10. Just a summary on page 3. But those are all the items that are largely are relating to what the commission has done and will intend to do in this coming year. So if there are any questions about any of the shaded items.
Any questions or comments from commissioners? Seeing none, any questions or comments from the public?
Mr. Chair, I apologize. I was a little slow.
Yeah.
I just wanted to make sure, Sharon, we're on the same page about my bio being the version that's in the supplement.
That's correct. We did do the supplement based on your request to change it. So as long
Thanks.
as you're okay with what's in the supplement, then
Looks
we're
good.
to go. Yeah, and thank you. Thank you very
Appreciate
much
it. Thank
for the
you.
clarification.
That's the one appendix that is also for the commission's approval is the appendix that contains all the biographies of the commissioners. And that's also included, but we have the supplement, which includes Commissioner Crio's biography.
Okay,
So, does anyone have any questions or comments about either the shaded material or anything else in the
any
annual
questions
report?
regarding the shaded material or really anything else in the proposed annual report? Seeing none, hearing none. Oh, and any public input? Don't see any. So this requires a vote, correct?
Yes, this is a final report that
Okay,
needs to be
is
approved.
there a motion to approve the annual report as with the modification of Commissioner Carrillo's bio? Kara,
I move.
moved? Is there a second?
I'll second.
Commissioner B, been moved and seconded?
Okay, I will call the roll. Commissioner V,
Aye.
Commissioner Carrillo,
Aye.
Commissioner Kubas,
Aye.
Commissioner Hebner.
Aye.
Sharon, turn your mic on.
Okay, why don't I start over? I'm so sorry.
No,
Commissioner.
I heard you. You're just really low.
Okay, then I'll move on to Commissioner Jenkins,
Aye.
and Commissioner Simpson.
Aye. All right, motion's approved. Thank you, Steve, for the work on this. And the last piece in administrative matters is open government laws.
Sure. So this is the annual reminder of the various open government laws that govern commissions, such as the California Law Revision Commission. It's broken into 3 pieces. A discussion of the Bagley-Keene Open Meeting Act, conflict of interest provisions that apply to commissioners, and the California Public Records Act. There's a lot of background material on the Bagley-Keene Open Meeting Act that you've seen before as far as definitions, notice, and content of the agenda, conduct of meetings, as I think everybody here knows that one of the major goals of the Bagley-Keene Act is that all state body meetings be open and public, and that the public has the opportunity to participate, that they're accessible to the public, which we certainly do. We have this very nice room that we're meeting in for those who were able to attend in person, as well as the ability to participate, for the public to participate remotely. One thing I wanted to highlight as I was looking back through it is there is a 10-day notice and agenda requirement, but that does not apply to a special meeting called by a state body to consider certain matters, including proposed legislation.
Oh.
So just wanted to highlight that for you all, because we may have a fairly active commission meeting process with regards to legislation this year. So if we need to do that, we do have the ability to do that. There are limited exceptions for when a commission can move, when the commission can meet in closed session. There are some rules relating to communication outside of a noticed meeting. We've discussed this before, but one of the most important things is that members, as you know, commission members cannot communicate about commission businesses outside of public meetings. So a majority of the members of a state body may not use a series of communications of any kind directly or through intermediaries to discuss, deliberate, or take action on any item of business that is within the subject matter of the state body. We've talked about this before as it relates to serial communication. Sometimes commissioners are approached by members of the public outside of a meeting, which is perfectly fine, and it's perfectly fine for commissioners to speak to individuals. The only thing that commissioners need to keep in mind is that there's some risk that a serial meeting could happen if, for example, a third party spoke to Commissioner A about something and then relayed that conversation to Commissioner B and then Commissioner C and Commissioner D, et cetera, et cetera. So the recommended practice, I think in our handbook, is that if a commissioner is approached by an outside entity, that they contact staff so that we can advise on that. Let's see. Teleconference meetings. I think that everybody here, the commissioners, have really embraced the ability to meet via teleconference. It helps when there's other conflicts, or certainly when travel is very difficult or would take an inordinate amount of time, maybe even longer than the meeting itself, to get here and back. So there are a few provisions relating to teleconference meetings. The commission has primarily been conducting, or has been conducting, the teleconference meetings. It's called teleconference meetings pursuant to section 11123.5 of the government code. That one is the most efficient. Another provision would require that there be more than one location and staff at more than one location, et cetera, to make it feasible. So the commission has certainly expressed that the commission prefers meeting under the teleconference provisions of 11123.5. That section was originally added by SB 4/4 with a sunset date. The good news is that that section has been amended again, and effective this year, it is the ability to meet under this section continues until December 31st, 2029. So it allows all members of an advisory body, which the commission has designated itself or defined itself as properly, I believe, in the handbook as an advisory body that is able to meet under this special teleconference authority. If that date is not extended beyond 2029, the commission would need to revisit how the commission would conduct teleconference meetings, which, as I noted, I think the commission has found very valuable. Does
Right.
anybody have any questions so far? I know I've been plugging along with this.
I don't see any.
Nothing so far. Okay. So the next starting on page 13, the memorandum discusses conflict of interest provisions. This is something that's included in every memo that we provide at the beginning of the year. There really hasn't been any changes to the law in this area, but just to summarize which ones provide, there's the Political Reform Act of 1974. As you know, commissioners are considered public officials as well as the relevant members of commission staff. And so the key issue there is whether a public official has a material financial interest in a governmental decision. The law and regulations are fairly complicated. On that, we do have a reference to the Fair Political Practices Commission's website. But if you are concerned that there may be an issue for you, you can always reach out to staff, and we can help point you in the right direction. Primarily where it might come up would be related to contracts entered into by the commission. Like I said, it's a fairly arcane area of the law, and we're always happy to help if you have any concerns about that. But we do caution that the commissioner should be cautious regarding potential contracting conflicts. And again, remind you, if you have any questions, please reach out to the executive director.
And the kinds of contracts that this commission has, there aren't very many, right?
No, there are not. And
Like office space kinds of things.
yeah, office space. We have the website. If we enter a contract for that, we have interagency contracts, which I don't think are the same thing. So there's not a lot of risk, but if you have, it is complicated. So if you have any questions, just let us know.
Right.
Let's see. Moving along. There is another body of law. It's section 1090 of the government code that pertains to contracts, and it would allow a contract to be avoided, in other words, voided by any party to the contract except the interested officer. So basically, if there's a conflict of interest, there's a potential that the contract could be voided. But if there's a willful violation, that could result in criminal penalties. So again, if you have any questions, just reach out to us. And then the final discussion is on page 18, and that relates to the California Public Records Act. The commission is subject to the California Public Records Act, which means that any of the documents that we produce, emails, et cetera, are potentially disclosable under the Public Records Act. All of our records are public records. Then the next question would be, is there any basis for withholding a public record? So for example, if there was a request for a public record that is attorney-client privilege, there would need to be some analysis of why that wouldn't be disclosable. And so luckily, we don't receive too many of them. They can be very time-consuming, depending on what the scope of the request is. And there's very specific procedures that the commission would need to follow to respond to a Public Records Act. We do want to highlight that Section 380 of the handbook, which applies to electronic communications. And so basically in the handbook, it says commissioners and members of the staff shall not use text messages or social media to send or receive a message that relates to the conduct of the commission's business. So in other words, even a text message is potentially disclosable under the Public Records Act. So it's really best to limit text messaging to things like perhaps if a commissioner is running late for a meeting, texting commission staff to let them know about that, or if you
What do you want
need
for
to
lunch?
meet- Yeah. But as far as what do you think about, this specific study, that
Yeah.
we recommend that we do not use text messaging to conduct that kind of business. So this does not need a decision from the commission. This is just a informational reminder that we provide every year with an overview of the open government laws that the commission is subject to. Like said, we're always available if you have any specific questions. Please don't hesitate to reach out to us.
Good, thank you. Are there any questions or comments from commission members? Seeing none, any public comment? Seeing none. Okay. The hour of 10:45, having
10:55.
10, yeah, well, having come and gone, it's now.
Oh, I'm sorry.
We're now able to take up item 3, recodification of toxic substances statutes, the cumulative draft.
And we would
Previously
like
approved.
to thank our ASL
Yes.
translator for being here. The translator is actually here specifically because for this study, because we've been requested to have him. Thank you so much.
Yes, welcome back. Welcome back. Steve?
Yes, thank you. So this is memorandum 2026-7. It presents another cumulative draft, very similar to the ones you've been seeing at each meeting, except including the provisions that were recodified that you approved at the last meeting and are now included in this cumulative draft. It's offered as just reference material. It doesn't require any decisions by the commission, but certainly any questions or comments are welcome. I did want to apologize that we were not able to finalize a discrete set of new provisions, which we normally have for the agenda. I have done more recodification, but the next set of provisions are quite complicated, and so we will include them in what's presented at the next meeting.
Okay.
Are there any questions or comments about the cumulative draft?
And this is an accumulation of all the changes that the commission has previously approved.
That's correct. The process is typically each meeting, we present a new
Right.
set of recodified provisions. If they're approved, they then are placed in the proper positioning within the cumulative draft.
Right. And as well as all the comments that relate to it, each section.
Well, right. The comments, the commission comments are already in the proposed recodification of each section.
Okay. Remind me where do the comments end up? If we approve this, where do the comments end up?
The comments are published by legal publishers. If the recommendation is approved as an enacted bill, it doesn't appear on the Ledge Council website. The comments don't appear there, but we send them to West and other legal publishers. And when they reproduce the enacted code sections, there is below the text of the code section, there's a highlight which says Law Revision Commission comment, and then our comment is printed there.
Okay.
And so that's typically used as evidence of legislative history because we have included those comments in our recommendation that we give to the legislature. So the presumption is that they've read the comments in deciding whether they want to adopt our recommendation
Mhm.
and theoretically have adopted the rationale or the explanation of the comment.
Right. And the comments can be, the comments are not mandatory or to have the same interpretation, but they are informative if this section gets adjudicated in court or something like that.
Yes, there's no requirement that we do the comments, but the commission has done these comments for
Right.
70
right.
years or so.
I can imagine it'd be helpful.
And I would just add to
Yeah.
that, we have a lot of discussion about that in the annual report, about how courts have recognized the value of the commission as, of the commission comments when interpreting statutes.
Okay, good to know. Are there any questions or comments from commission members? Seeing none, hearing none, any public comment? Don't see any. And so, and since this is an accumulation of material that have previously approved, there's no requirement that we vote on this now, right?
That's correct.
Okay. Thank you, Steve, as always. We will then, since there's no public comment, we don't need to take a vote. We have concluded with that agenda item, and our ASL translator is free to go off and have lunch, I guess. So, or cup of coffee or whatever. And we appreciate your help and probably look forward to seeing you at a subsequent meeting. Thank you so much. All right, it's now 11, right? Yeah, it's now 11. And the next item on the agenda for us to consider is antitrust. I'd like people's input on that. We could start it, but then we'd have to take a break around noon for lunch. Or we could take a break now and then sort of interrupt what we're doing and then continue after lunch. Or we could take a break now, maybe have early lunch if the lunch is available
The lunch should be available at 11:30.
at 11:30. So what do members think about, do we want to start antitrust now and then break 11:30-ish? Or take a break now and then come back at 12:30 or so and start, so we don't have to interrupt the presentations and conversation about antitrust.
And I would just add to that, that I believe Commissioner King will be here
Yes, and
by
Commissioner King
noon, so.
should, by about noon, Commissioner King ought to be here. So what do people think?
I would start.
You would start? Yes? Yes, okay. They want to start. Are you going to stay with us? Okay. All right. We can start. We have memo 26-10 and 2 supplements. Sarah? Yeah, no, well, antitrust.
Sure. So, as you know, the commission at its last meeting approved a tentative recommendation for circulation to the public for comment. We have done so. We, in this memorandum, we have, in this memorandum and the supplement, we have the public comment, and we've also made a number of technical edits and minor changes to the tentative recommendation that we didn't call out because, you know, it's moving in a period there, making sure the case citation is correct, things like that. But we do have a few suggested improvements to the proposed statutory language
Okay.
that we do discuss. I will, and then in the supplement, we have an additional recommendation, which I will go over in a few minutes. But just to point to, we have a lot of information about the public commenters, and where they're coming from. The summary of the public comments is included in a separate memorandum. In the first memorandum, we said that we did not have any suggested changes in response to the public comments. However, in the when we were going back through and summarizing them, we realized that another, I would say, technical or clarifying change would be helpful. So if you turn to starting on page 6, we talk about the update to the commission approved language.
Mhm.
And one thing that happened is that one of the code sections we were proposing was added to the Business and Professions Code effective January 1. So we needed to go back and renumber the proposed sections in response to that. And then also in looking at it, we thought we are suggesting that we reorder the provisions a little bit so that the purpose statement appears first.
Mhm.
We think that's consistent with accepted legislative drafting practices, which generally order purpose statements before the operative language. That could, I would have suspected if we hadn't recommended this, that the Legislative Council probably would have pointed that out in the draft. So the first change would be to have the purpose statement appear first as section 16.730. And we also made accompanying changes to be consistent.
On the section numbering.
Yes.
Right.
And then the second one is the operative provision, which would be renumbered as 16.731.
Mm-hmm.
I don't believe there are any other changes to that. And then section 16.731, which is the judicial guidance section, would be renumbered to section 16.732. We also have another recommended change on that, which would be to only apply this to the operative provision, because that's actually what it's intended to apply to. It does not need to apply to the purpose statement. So I'm going to ask Sarah if she has any. Did I miss anything here so far? Okay. Do the commissioners have any questions at this point?
Seeing none?
I do.
Oh, yeah, David.
Sorry.
Rio.
And I fully acknowledge I just might not be understanding this. But on the original memo 26-10, there's something that occurs several times. The first example of it is on page 7 in subdivision D.
Mm-hmm.
So stay with me here for a second. So this section that's on page 7 is after the strikeout, it's numbered 16730. And then in
Right.
subdivision D, it says at the end of that paragraph, comma, including section 1730. So it seems like it's referring to itself.
To itself.
So it is that right? That looks wrong to me.
I do not believe
Good catch.
that.
And there are several instances of this throughout the memo because the language gets repeated multiple times. It shows up on page 12
Okay,
And Sarah's right.
and page 23.
Thank you, Commissioner. My understanding, my recollection from these discussions was that we wanted the interpretation of case law to be consistent with the intent of this particular statute. So we wanted to refer to the purpose statement of this law when
So-
folks are
so I
considering
think when we
change.
renumbered this, this should probably be 16731.
Right. So if we're renumbering, then the number would change anyway. But as long as we have to make changes to this, would it make more sense? Because it looks like an error. It looks like a typo. It looks like this is intending to refer to a different section when actually it's supposed to refer to itself. So can we just say including
This section.
this section?
I think that would work.
I believe that we intended it to apply to the operative provision, 16731. Sarah disagrees with me.
We can review the meeting. I believe we can find what the original intent was.
Right.
We can
Okay.
review the previous meeting transcripts to determine
Yeah,
that. and we
if
can
it's
make a
meant to refer to something else,
corresponding
then
change.
it is a mistake, and let's change it so that it refers to the correct section number. But if it's
Okay.
self-referential, let's take the number out and say
Yeah, and
this
take this
section.
section. Right.
Okay, we can look into that and maybe we
Consider
can even
corrections.
look into it over lunch and give you a more definitive answer on that.
And I'm looking at that subdivision and it says may consider federal case law as persuasive authority to the extent that they find it consistent with California law, including, I assume it would say including this section.
Yeah.
Yeah.
I think that's what we mean.
Yeah.
I will consult with Sarah and Cheryl over lunch and get back to you.
Thank you.
Okay. Good catch.
Yes, actually, when I was looking at it, I'm like, oh, it has the same section number. The things you see when you're
Yep.
when you're looking at things again. Okay. Now I'm going to turn to the first supplement. So the first supplement lists or attempts to give a good faith summary of all the comments that we received.
Mm-hmm.
As you will see, they're in detail. Some of the comments we received are consistent with what we've received before. Many of them express concerns, but other groups are urging the commission to adopt the recommendation as is. I'll just briefly walk through them. The American Bar Association antitrust law section did not take a position on the recommendation, but thought that it should incorporate some limiting principles to assist businesses and courts in distinguishing between lawful and unlawful single firm conduct. However, they did not provide any suggestion on how the language would be changed. The American Economic Liberties Project and their partners encourages the commission to approve the draft without change. They list a number of reasons why they think that the recommendation should be approved. ASM Games is a small business that had some concerns that the recommendation could limit the abilities of small business to access and integrate tools that integrate analytics and data pricing and fulfillment options that help them compete on a level playing field. But again, they did not request any specific changes to the draft language. The Bay Area Council is opposed to the tentative recommendation. Their concerns are set forth in the summary. We have a quote from them, but they are concerned that there could be real world harm for consumers and businesses. The California Chamber of Commerce, which the commission has heard consistently from throughout the process, starts with a threshold belief that changes are not necessary to California's antitrust laws, and also disagrees with the commission's process and tentative recommendation. So one of the points that Cal Chamber has made throughout the process is that they think there needs to be a study on whether any changes are needed or not. That would be more of an economic analysis. That's not within the expertise of the commission. As we know, the commission was directed by a concurrent resolution to conduct a study in the manner reflected in that concurrent resolution. So the Cal Chamber's comments are consistent with what they've stated before. California Life Sciences submitted a couple letters. One was just before the last commission meeting. They continue to have concerns about the tentative recommendation. They raise concerns about the use of the term restraint of trade, the prohibition on considering pro-competitive benefits in adjacent or complementary markets. They believe is a significant departure from established antitrust principles. So they raise concerns specific to how they believe that the proposal could impact the life sciences industry. The Chamber of Progress is urging the commission to reconsider its tentative recommendation and remove section 16731, which is what's now numbered subdivisions C's, prohibition on considering cross-market effects. As I'll explain in a few minutes, they weren't the only organization to raise concerns, and we do have a recommendation that we believe will help clarify what that subdivision is supposed to do. They also raised the concern that the judicial guidance provisions are structurally one-sided. The Connected Commerce Council, or otherwise known as 3C, also raises concern that the recommendation could hurt small businesses. And then we heard from Professor Daniel Francis, who submitted a lengthy comment going through the commission's recommendation with specific concerns. While he supported the commission's effort to introduce a monopolization offense into state law, he did have concerns about how the tentative recommendation is drafted. The Information Technology and Innovation Foundation, we've heard from them before. They expressed concerns related to the term restraint of trade, again, stating that they're concerned that it's overbroad. Tech Freedom also submitted a lengthy public comment. I believe that I've heard from them that they will be making public comments when we get to that portion of the meeting. But they have concerns. I don't think that they're not saying that reform isn't needed, but they believe that the recommendation should be revised.
And we may be
They
hearing
also
from them.
pointed to a number of concerns about that. the Bay Area Council and some partners also submitted a comment right shortly before the last commission meeting and raising concerns that the recommendation would harm the business community and prohibit everyday pro-consumer business practices, have concerns about how the recommendation treats existing law, etc. And they are worried about uncertainty.
Okay.
The U.S. Chamber of Commerce also expresses concerns about the tentative recommendation. They appreciate the transparency and robust process of the commission, but recommend that California maintain its current legal framework and instead focus on enforcing existing laws vigorously. Y Combinator actually wrote in strong support of the commission's tentative recommendation. They're a venture capitalist. Sarah, you can chime in if I'm getting this wrong, but I believe a venture capitalist firm that's supported the launching of a lot of startups like Airbnb and similar companies. And they believe that the recommendation or changes are necessary to support the ability of startups to compete against larger established companies. So that's their perspective.
Okay.
Okay, so going back to the proposed revision.
Now, are you looking at the
So-
second supplement?
Yeah, in the second supplement, page 2. As I noted, we had previously indicated that we were not recommending any changes based on public comment. But after further consideration of the comments and consulting with the commission's antitrust expert, Ms. Cheryl Johnson,
Mhm.
who's with us here, the staff is recommending a revision to propose section 16731C. And on page 2, it sets out how it reads now. On page 3, it sets out how the commission or the staff recommends that the language be changed. And basically, what we're suggesting is that to avoid any confusion, that the subdivision C be revised to more closely mirror existing California case law. That would include striking the use of purported, I'm sorry. It would strike the word purported, because that is not something that the established case law looks at. They look at what's really happening, not what is purported to be happening. So the revised subdivision C would read anti-competitive effects and pro-competitive justifications of the challenge conduct shall be evaluated within the same market. And that language is based on the Marsh case, which is reflected in the memorandum, and more closely tracks the language in the California case, which is the point here that I think the commission is trying to make with the recommendation in general, is that California law is distinct from federal law. And this is one instance and where a clarification would be beneficial. One of the concerns when the commission originally decided to add this language at the suggestion of some of the public commenters was that there's some confusion on the federal level about how this is actually done when a case is considering it, and that it's fairly clear under California law how California courts believe the analysis should be done. Again, the staff believes that that more closely tracking the language of the existing California case law makes that clarification, improves that clarification.
So
And, sorry.
what this, correct me if I'm wrong, what I think this what it clarifies is that, in a antitrust case, you can't say, well, the actions I'm taking may be harming competitors in this market, but businesses in some other market are benefiting, and therefore I ought to be, offsetting the benefits in this other market offset harm in the first market.
Yeah.
It's saying you can't do that. You have to look at benefits and costs within a market.
Right. So the court, and I'm going to ask Cheryl to chime in, but the court will define for purposes of doing this analysis what the relevant market is. And then those effects are looked at within that defined relevant market.
Okay.
So Cheryl, did I say it right?
I think you said it fine. I think it's just a bedrock principle of California antitrust law that you offset harm or you weigh harms and benefits in the same relevant market. That's a clear concept that is expressed in many of our cases, including Marsh and Flagship. And we used to think we were aligned with federal law, but some recent cases have suggested that parties are testing the boundaries of that law under federal law. So that's why we agreed to enshrine the no cross marketing kind of ban here. But when we looked at the comments, we then could see that that section that was in section C that banned offsetting harm from one person to benefits to other persons wasn't limited to the same relevant market, and it could become problematic and could be read in the way that some of the public commentators were suggesting. And it also isn't clear under California law. So we went back to the bedrock principle of California law and just limited that to what California law says, which is you look at benefits and harms in the same relevant market.
And that, when you say California law is, that's court decisions that have pursuant to the California's Cartwright Act?
Yes.
Okay. Okay, thank you. You can keep going.
So
Sorry.
I've talked a lot this morning, so bear with me. I just wanted to point out that in the second supplement, we have.
Lean into your mic, please, Sharon.
Sorry about that. I just wanted to point out in the second supplement, we do provide an additional comment from Tech Freedom. We received it late, so we don't really have much of a summary of it. And as I said, my understanding is that Tech Freedom will be speaking in public comments, and they can certainly speak to this particular public comment as well as the one that they previously provided.
Got it. Go back. Do we need to take an action to make the modifications?
I think
that
we
were-
should wait
Okay.
for public comment.
Got it. Okay, that's a good idea. Okay.
And It's
Is
almost 11.
Is this, is this the time that we can, almost 11, and so the next thing we would do would be take public comment on the whole?
Yeah, and
So-
then to see if the commissioners have further questions, if you have further questions about the public comment. And I do believe a number of folks will be here, so if you have,
And Commissioner King will be able to join.
and Commissioner King will be here.
So it's okay if we take our break? And hopefully they'll be some lunch, and we can reconvene at, say, 12:30?
That should work.
Okay. All right,
Was that 12:30?
12:30? All right. I got a thumbs up from Hebner, so I think we're good. Okay, we will now reconvene. Commissioner King has been is able to join us now. He's here. We still haven't seen Commissioner Pacheco, but we'll keep her out in case she's able to join us. And we still have a quorum present. And so I guess we will now move to public comment on on item 5, antitrust law, single firm conduct. Should we do in person first or online first?
Yeah, let's do in person
Okay.
first. And it looks like we have a number of folks who are interested in commenting. So we're asking you to keep it brief and no longer than 5 minutes.
Because we have quite a few. We have, I think, up to 27 people online. And I don't know if they're all going to talk or not, but okay. Okay. So who'd like to go first? The gentleman in the front row. Welcome back.
Great. All right. How's that working? Good. Okay. Well, good afternoon, Chair and Commissioners. Thanks for the opportunity to comment. My name is Ben
Maybe try
O'Brien.
a little louder and a little
Sure.
closer.
Yeah, sorry about that. Good afternoon, Chair and Commissioners. Thank you for the opportunity to comment. My name is Ben O'Brien, and today I'm speaking on behalf of California Life Sciences, where I serve as the Director of State Policy Analysis, as well as the Los Angeles County Business Federation, who's a partner organization whose representative cannot attend today's hearing, but asked me to speak on their behalf.
We're still having a little trouble hearing you. so-
Sorry about that. I just don't want to okay. California Life Sciences represents more than 1,300 organizations across California's life science economy or life sciences ecosystem, including biotechnology, pharmaceutical, and medical technology companies, as well as world-class academic and research institutions. While our partner organization, Los Angeles Business Federation, is an alliance of more than 250 business organizations representing over 5 million employees across the Los Angeles region. It unites chambers of commerce, trade associations, minority business groups, economic development organizations, and other employer-led groups to advocate for policies that strengthen the regional and state economy. Both California Life Sciences and Los Angeles Business Federation are deeply concerned that the Commission's proposed single firm conduct recommendation would jeopardize California's economy by creating broad and unpredictable antitrust liability for businesses of all sizes across all sectors. Specifically, the proposed additions to the Business and Professions Code would significantly expand single firm liability beyond existing state and federal standards, while removing traditional analytical guardrails courts rely on to distinguish lawful competition from exclusionary conduct. This combination creates substantial legal uncertainty and risks unintended consequences for research and development, biomanufacturing, supply chains, and collaborative partnerships that are essential to delivering treatments to patients and supporting economic growth. In the life sciences sector, innovation depends on long-term investment, exclusive licensing, scale efficiencies, and coordinated activities across research, clinical trials, manufacturing, and distribution. Under the recommendation, ordinary pro-competitive conduct necessary to bring niche or high-risk treatments to market could be challenged as unlawful without showing of market power, market definition, anti-competitive intent, or consumer harm. The recommendation would further prevent courts from considering the full economic picture. Judges would be barred from weighing downstream benefits to patients, researchers, or the broader healthcare system when evaluating alleged harms defined within a market. In sectors like life sciences and healthcare, where benefits frequently materialize across interconnected, multi-sided markets and over long time horizons, courts must retain the ability to assess benefits broadly rather than in isolation. While we recognize the revisions proposed in Memo 2026-10 that appear to respond to this concern, we have not had adequate time to review them fully and remain of the position that courts should retain the ability to evaluate the full economic picture when weighing harms and benefits of conduct. Finally, we'd like to raise the concern that the recommendation explicitly encourages broad and liberal interpretation of antitrust law while treating federal precedent as non-binding. Combined with the elimination of evidentiary safeguards, this framework would invite opportunistic litigation, chill collaboration, and discourage investment, particularly for startups and research-driven sectors. California has built the world's leading life sciences ecosystem and a competitive global business climate by fostering collaboration, sustained investment, and legal predictability aligned with federal antitrust principles. On behalf of California Life Sciences and LA BizFed, we respectfully urge the Commission to reconsider or substantially narrow this recommendation. Our concerns within specific sections are expounded upon in our written comments. Thank you for your time and consideration.
Thank you. Is there any question or comment for this presenter? Hearing none. Thank you so much. Next.
Hello, Commissioners. Good afternoon. My name is Gilbert Lara. Thank you for the opportunity to speak on behalf of Biocom.
Excuse me, can you lean a little bit more into the mic?
Sure.
We're having trouble hearing you. Thank
How about
you.
this? Can you hear me now?
That's better.
Sure. How about this? Okay. Thank you again for the opportunity to speak here on behalf of Biocom California, the largest life sciences trade organization in the world. Our members include biotech, pharmaceutical, and medical device companies of all sizes, along with research institutions, investors, and service providers. The life sciences industry is the second largest industry in the state, including more than 17,000 companies, and generates nearly $400 billion in economic output. These companies take on long-term scientific and regulatory risk, and the rules under consideration today will influence whether those investments happen here in California. We are concerned that proposed business and profession codes, sections 16730 and 16732, would create uncertainty and costly exposure that is difficult for innovative life sciences companies to manage. First, the liability standard is overly broad. Early-stage biotech firms often operate in specialized areas where only a few firms can meet validation, safety, and manufacturing requirements. The draft code changes increase the risk that ordinary specialization is treated as unlawful power without predictable screening tools. Second, the proposal puts legitimate intellectual property-based business models at risk. Licensing, exclusive research partnerships, and long-term supply and manufacturing agreements are central to developing drugs and devices. Section 16731B would treat as a restraint of trade conduct that is included or cognizable under Section 16720, even when it is directed, caused, or performed by a single firm. Combined with Sections 16732's reduced reliance on familiar indicators, these provisions could pull routine, often pro-competitive arrangements into expensive litigation by weakening standard analytical guardrails. Third, Section 16731C, which was recently amended, still creates problems for platform technologies. It says harms in one market cannot be offset by benefits in a separate market, and harms to one person cannot be offset by benefits to another. In life sciences, platform benefits often span research, manufacturing, and distribution. If a case is framed around a narrow market slice, such as one license or one supply segment, courts may be required to disregard efficiencies outside that slice, even when they improve patient access. Biocom respectfully urges the Commission to narrow and clarify the proposal so it targets truly harmful conduct without undermining the collaborative, IP-driven models that support life science innovation in California. Thank you.
Thank you. Are there any questions or comments for this presenter? Seeing none, thank you so much.
Good afternoon. How's that on volume? That work? Okay,
So
great. Chair and Commissioners, thank you very much for the opportunity to offer brief remarks today. My name is Rusty Knudsen with Platinum Advisors. I'm appearing today on behalf of our client Y Combinator, the startup accelerator that has helped launch more than 5,000 technology companies over the past 2 decades, including household names like Airbnb, Stripe, Reddit, and Instacart. Y Combinator's head of public policy, Mr. Luther Lowe, submitted detailed written comments supporting tentative recommendation B-750 earlier this month. He's traveling internationally today, but asked me to reiterate YC's strong support for this recommendation and urge the Commission to approve it. A couple reasons why this matters to startups. First, startups are the canaries in the coal mine for anti-competitive conduct. They feel the effects of exclusionary behavior by dominant platforms long before it attracts government scrutiny or makes headlines. YC companies have experienced self-preferencing, denial of API access, and outright foreclosure from markets controlled by gatekeeper firms. Second, California's current law has a gap. The Cartwright Act primarily addresses concerted conduct, not single firm abuses. This recommendation fills that gap, bringing California in line with the majority of states that already outlaw monopolistic practices by individual actors. Third, the legislative guidance in Section 16731, rejecting the most restrictive federal precedents like Trenco and Brook Group, is critical. These judge-made rules have made it nearly impossible to hold dominant firms accountable for plainly exclusionary conduct. California should not import these limitations. Some opponents have argued there's no market concentration problem in California. With respect, that position ignores reality. As Y Combinator's CEO Gary Tan told the U.S. Senate last year, the unchecked concentration of power in big tech has created, quote, kill zones, where venture investors, including Y Combinator itself, won't even fund startups because dominant incumbents can crush them instantly. Y Combinator urges this commission to approve tentative recommendation B-750 and send it to the legislature. California has the opportunity to lead the nation in updating antitrust law for the modern economy, an economy that was born in our state's startup garages. Thank you for your consideration.
Thank you. Are there any questions or comments for this presenter?
Mr.
Commissioner
Chair,
Correa?
thank you. I just wanted to thank Y Combinator for its very thoughtful, well-written, and compelling comments.
Thank you, sir. All right. Any other questions or comments? Hearing none. Thank you, sir. Who would like to be next?
Hello, Chair and Commissioners. Thank you for the opportunity to speak today. My name is Robert Boykin with TechNet. We share the Commission's goal of protecting competition and consumers. Our concern is that the current proposal would fundamentally reshape California's antitrust framework in ways that risk harming innovation and consumers. California's antitrust laws have a long focus on harmful conduct, not business success. The proposals aim to treat market share or scale as proof of misconduct. That shift risk penalizing companies for consumer preferences rather than anti-competitive behavior. Routine pro-consumer practices such as discounts, partnerships, and integrated products could be considered unlawful. There are practices that often lower price. These are practices that often lower prices and expand choices. The likely result is less innovation, higher costs, and more uncertainty across industries. Existing antitrust laws are robust and actively enforced. The Commission has not identified a clear gap that would justify replacing them with an untested framework. Lastly, we are also concerned about the process. The Commission's amendment posted this week had less than 72 hours of public review. Given the scale of these proposals and their impact on virtually every business in California, we urge the commission to delay and any final recommendation until March to allow meaningful public input. Lastly, given the scale of these proposals, once again, I was
Okay.
scrolled. A recommendation of this magnitude could lose credibility without robust public vetting. We appreciate the commission's work and stand ready to engage on a more targeted, evidence-based approach. Thank you.
Thank you. Any questions or comments for this presenter? Seeing none, thank you. Who would like to be next? Oh, okay, we're going, 1, 2, 2. Even, odd? Yep. Okay.
All right. Can y'all hear me well?
Yes.
Awesome. Thank you, committee. My name is Loyal Terry on behalf of Economic Security California, and in solidarity with many of the organizations you're hearing from today, we applaud the commission on nearing the conclusion of this process to hopefully get our state's antitrust laws up to date. After many years of extensive study of California's current antitrust laws, with recommendations from academics, researchers, and practitioners, both public and private, we are ready for the commission to take the next step today. From this strenuous review process, you have a well-balanced proposal in front of you that would substantially strengthen our state's antitrust laws and enforcement. If implemented, these recommendations would close loopholes that have allowed monopolies to abuse their market dominance, making it clearly illegal for single corporations to block competitors, suppress wages, or use power in one market to dominate another. This would give California independence from weakened federal standards and remove legal barriers that have let corporations escape accountability. Specifically, these recommendations distinguish California antitrust law from federal law, rejecting proposals that would have thwarted reform by tying us to weakened federal standards, close the single firm loophole by making monopoly conduct as illegal as collusion, hold gatekeepers accountable by prohibiting dominant firms from restraining trade or leveraging power across markets, protect workers and suppliers by explicitly covering monopsony, which, as you all know, means preventing dominant powers from suppressing wages or squeezing sellers. Give California independence from weak federal precedents, as I had said earlier, and clarify what is not required to prove an antitrust violation to better allow courts to reach the merit of cases. The recommendations that you are voting on today are well balanced and timely. People need change now. Californians cannot keep paying the price at the grocery store or when they're buying health care or when their small business is being squeezed by mega billion-dollar corporations. When a handful of companies control entire markets, they can charge families more for groceries, rent, and everyday necessities, all while paying workers less. The commission's recommendations represent a real opportunity for our state to update antitrust laws so they have real teeth. After all of these considerations, we are proud to support this recommendation. Thank you.
Thank you. Are there questions or comments for this presenter? Seeing none, thank you. Thank you. Who would like to be next? You were even or odd? Yeah, okay.
That's what I get for losing rock, paper, scissors. My name is Ryan Elaine on behalf of the California Retailers Association. Appreciate the opportunity to comment on this draft recommendation on single firm conduct. As mentioned before, and other speakers, we share the commission's objective in ensuring robust competition, but we have concerns that the proposed framework would introduce substantial uncertainty and litigation risk for retailers and their suppliers operating in a dynamic, low-margin environment. The proposed statute's expansion beyond the traditional monopolization to encompass unilateral restraints of trade without clear statutory definitions or established precedent is likely to blur the line between pro-competitive retail conduct and genuinely exclusionary behavior. Retail markets rely on practices such as promotional pricing, category management, and investments in private label offerings, all of which can intensify interbrand competition and deliver low prices, broader assortment, and improved services for customers. CRA is concerned with the breadth of the open-ended nature of the proposed liability standards. Could chill these practices, especially where the draft guidance appears to designate to make liability less restrictive under federal law and to de-emphasize well-settled federal jurisprudence on the conduct such as discounting, refusals to deal, and other unilateral decisions about how to deploy retail shelf space in digital storefronts. I just wanted to keep my comments brief. I wasn't able to get too much feedback on the recent revisions this week. And I'd also just, in addition to asking you to reconsider this proposal, to delay to allow some meaningful input in the coming months. Thank you.
Okay, thank you. Any questions or comments from the presenter? Seeing none. Thank you so much. Who's next? Is that? Okay.
Can you hear me okay?
Well, welcome.
Good afternoon, Kristen Heidelbach here on behalf of United Food and Commercial Workers Western States Council. I just would like to offer 4 brief points. First, the CLRC has studied this for years, considered hundreds and hundreds of comments, made numerous changes in response, collected through its working groups the expertise of numerous national experts, including those who have spent much of their careers representing big business. Second, after all of this and after so many years, the CLRC's recommendations could not be more modest and surgical, simply clarifying in code the relationships on key issues between federal and state law. Aside from amending California law to align with the federal government and most states to permit actions against one company, those clarifications of existing law are the very modest sum and substance of the proposal before you. Third, many of the opposition arguments before you are arguments that oppose California law being different and more protective of consumers than federal law. But as your own staff makes clear, California law is already different and already more protective than federal law. And those who oppose the clarifying proposal before you are in many instances actually asking you not just to embrace the status quo that none of your experts embrace, they are actually asking to move California law backwards. And fourth and finally, this is urgent work. Your working group on market concentration says we are in a food consolidation crisis. Crisis, their words, not ours, is a crisis about no less than food for California's families. For these reasons, please vote to endorse the single firm conduct proposal before you. Thank you.
Thank you. Any others in the room would like to speak? Seeing none, should we go to folks online? And how many hands are raised at the moment?
14.
14. Okay.
Thank you. Thank you, commissioners. Thank you, staff. Thank you for this time. My name is Bilal Sayed, and I am Senior Competition Counsel at Tech Freedom, a legal policy think tank funded in part by private businesses, including companies operating in California, as well as family and institutional foundations. My comments are on behalf of Tech Freedom and draw on my experience in private practice, government service, and as an adjunct professor. No funder of Tech Freedom has directed these comments, and the same is true for the comments submitted in writing. I believe, as the executive director noted, we do not support the final draft recommendation, but we have also not taken the position that reform of Section 2 is unthinkable. We do believe that development of existing federal law is a better way to reform monopolization law. We do not believe that Section 2 is ineffective. Our comment of January 14th identifies a number of recent monopolization victories by the government at both the merit stage and the motion stage, and even more monopolization investigations and successful enforcement actions by the government through settlement. The reasons we do not support the recommendation are stated in our submission of January 14th, and our position has not changed with respect to the draft final recommendations. In short, we believe some of the recommendations are wrong as a matter of policy, including the adoption of a single firm restraint of trade prohibition and the judicial guidance that would direct the courts to not follow certain cases, including but not limited to Brook Group, Trinco, and American Express. In addition, we do not believe the recommendation provides a clear alternative analytic framework to application of the rules and principles discarded. This will create a significant potential for poorly reasoned decisions that may, in practice, rely on earlier poorly reasoned federal decisions that mistook harm to competitors for harm to competition and harm to consumers. We have three alternative proposals or suggestions, which I will sum up quickly. First, we believe the recommendation is a poor recommendation because the commission and the staff have failed to engage on the merits with commenters and others with different views on a proper application of the antitrust laws to single firm conduct. Now, identifying a unitary theory of the proper scope of anti-monopolization law is probably impossible, but I believe it is possible to get to broader agreement than exists with respect to this recommendation and get to a better proposal. We believe especially that there is strong discomfort with the single firm restraint of trade clause and the potential for it to do substantial harm to innovation, competition on the merits, and eventually to consumers. Second, we believe that a purported deficiency of federal monopolization law is not in fact linked to the substance of federal monopolization law, but the speed with which matters are adjudicated. As illustrative examples, consider the FTC's recent loss in its monopolization case against Facebook for its purchase of Instagram and WhatsApp, cases I have familiarity with from my time at the FTC. And also consider the scope of the remedy intended to effectuate the liability decision in the Google search case, which the DOJ won. And I think this may be an issue in the remedy decision and effectiveness of the remedy in the Google ad tech case, also DOJ won. In short, the slow pace of litigation allows for markets to change or solidify such that after all the effort, it is fair to wonder whether that effort was worth the win, if you win. As an alternative focus of the Commission, and I believe it is responsive to the questions put to it, if you believe some state action is necessary, we suggest the Commission consider adopting the existing federal law, but adopting new rules for trial and appellate practice that speed up adjudication of monopolization cases in the California courts, state courts. The legislature might couple this with more money for the state AG's office to bring more meritorious monopolization cases. And finally, I recognize that these proposals require a recommitment of the Commission's time, and thus while I think they are meritorious proposals, I want to propose something that can be done quickly, that I think will improve the statute. Our third and final recommendation is that the Commission make clear what I believe the staff expert noted earlier. If the Commission includes the judicial directive language in its recommendation, we believe the Commission should make explicit that the state courts, in interpreting the application of the new statute, must engage in the structured rule of reason and balancing approach of the appellate decision by the DC Court of Appeals in United States versus Microsoft. I believe the staff expert indicated that California antitrust law allows, or perhaps requires, balancing. I am less sure of that, in part because there is no existing general purpose single firm conduct law. But if that is the position of the staff, it should be explicitly incorporated into the judicial guidance. While this is not a perfect fix to what I believe are the errors of the recommended statute and guidance, it will have the effect of requiring courts to focus on harm to competition and not merely harm to competitors. The Microsoft decision is not perfect, but its framework does allow for the further development of pro-competition rather than pro-competitor monopolization law. The two recent decisions, Google decisions, finding liability, were litigated and decided within the Microsoft framework. Thank you for your time. I'm prepared to answer any questions or prepare a further written submission if you believe it would be helpful. Thank you.
Thank you. Are there any questions for this presenter or comments about the presentation?
Mr. Chair,
None? Oh, yeah.
I was just wondering if our consultant had any responsive comments.
Cheryl?
Okay. In terms of the recommendation that we use a structured rule of reason as per Microsoft, our California Supreme Court has said in the Cipro case that the courts already have the flexibility to structure the rule of reason analysis in a way that's consistent with the facts and the industry at issue in the case. So we typically use a rule of reason approach in already analyzing the antitrust cases, and there's nothing in our recommendations that are going to change that. Still, the courts are tasked with a very fact-specific assessment of the competitive effects of the conduct before them.
Does that
So
help, David?
Look, I will accept that. I will accept the expert, the staff expert's view on that. I would just respond in two respects. One is, of course, that's not really in the context of single firm conduct, right? Because as we know, California does not have a general purpose single firm conduct law, and federal monopolization law is not entirely clear that a structured rule of reason approach is the only approach or even the necessary approach in federal monopolization cases. So, I won't dispute what she says, but I think it's with respect to, Section 1 or Cartwright Act cases under California law. And then if what, and again, I don't doubt what she says is correct as stated, but if it is the position, then I think it would be useful to put it into the judicial guidance, right? I mean, I think even in her comments, the staff expert said something like, they could do this, right? I'm suggesting that you make it clear that they should do it. And the reason I suggest that they should do it is because I think it is the best tool for development of the law. But more importantly, if it is the position of the staff that California law either allows or requires this, I think it's worth putting in the statutory language or the draft guidance to courts, because it is not clear to many of us that the statute or the proposed statute recommendation does either require or favors this kind of structured rule of reason and balancing approach. So, I think if California allows it, I think you should make it clear that this is not only allowed but the preferred approach, and it ought to be in the guidance, because not all readers, including myself, believe that is clear, right? There's a lot of, in a sense, I'll call restrictions on the courts. Don't follow this case, don't follow that case. We have concerns about that, but that's in our written comments. Here, I'm suggesting a positive statement, positive direction to follow the structured rule of reason and balancing approach, in part to make it clear, and in part because, based on my thinking about this for nearly 30 years in government and private practice, while there are limitations of balancing, it is, I think, the most pro-plaintiff framework under existing law, and it allows for the continued common law development of, in this case, it would be state law, but also in federal law. So, my sense is if there's agreement, let's put it in the language.
Cheryl, any further comment?
Well, I think there's a long history under California antitrust law of the courts using a rule of reason analysis where a per se or a quick look or a structured rule of reason isn't in order. So I would disagree with the speaker that we now need to enshrine that in the statutes. And I think structured rule of reason is not a concise term. It gives the courts flexibility how to structure the burdens of proof.
What to put on the plus and the minus side of the equation?
Well, who has the burden
Right.
on various elements? And I think our law is fairly clear on that. We aren't necessarily aligned with all of the federal cases, but I don't see a big need to figure out what cases are going to be decided by a rule of reason, a structured rule of reason, a quick look, a per se. I think that's fairly already well established under our law.
Okay, thank you.
I think that, I think that requests, I'm sorry,
I'm
go ahead.
Victor has a question or comment.
Not getting audio from Victor.
How's that?
I can hear you now.
Okay, thank you very much. It seems like the speaker would like a more definitive statement that California will follow the rule of reason, and you're clearly saying that's an option, and that there's at least two flavors of rule of reason, a structured one and a non-structured one. So I don't see the speaker as being clear as to making that distinction. He really wants a specific type of analysis here and is not acknowledging what you've recommended and what the statute says, which is that, yes, rule of reason oftentimes is the methodology, but it's not necessarily always the methodology, much less the structured version of it. With all that said, to allay fears of the speaker or other people, would it be helpful to have some comment referencing the fact, not changing the statute, but you know how we always stick in comments from time to time, a comment reminding people and practitioners that there is this long history of the rule of reason being available as opposed to being, you know, mandatory, but being available as still, within the spirit of these statutes.
Well, I think that's already captured in section 16730, section C, where we acknowledge that California law departs from federal law in that we recognize the structured rule of reason and different burdens of proof. That's on page 1112 of 2026-10.
Oh, I see. Yes. At the end of subdivision C.
Yes.
Okay, so no comments necessary because you say it's already there.
Or actionable market share, structured rule of
Yes.
reason, and different burdens of proof, right? And differing burdens of proof.
So
Right.
if I can
Okay.
respond.
That's an
Thank you.
option. It's explicitly an option.
So I would
Okay,
just,
Mr.
I would-
Thank you, Mr. Said.
Chair,
Yes.
no, I was going to say I'm interested in hearing the other comments so that we don't run out of time with the people waiting to speak.
Right. Thank you. I know we've got a pretty long list. So thank you, Mr. Said. We appreciate your comments. Okay, next presenter.
Eric Ensign.
Thank you. Good afternoon. This is Eric Ensign with Kroll and Mooring on behalf of the California Chamber of Commerce. Can you hear me okay?
Yes.
Great. I'm sorry I couldn't be there in person today, but am appearing virtually to again speak in opposition to the single firm conduct proposal. As noted this morning, from the start of the process, we've repeatedly stressed that there is no economic analysis demonstrating the need for a single firm conduct law in California. And we don't agree with the comments this morning that the commission doesn't have the power or authority to commission an economic study to determine whether there's a need for creating new laws in California. As a reminder, in our May 2025 public comment, we described how this kind of study could be performed and our view that it should be performed before proceeding. Now, to be clear, the single firm conduct working group did not perform an economic analysis of these issues, but instead offered their personal views on how California law could be amended. Those opinions should be considered by the Commission, certainly, but they should not drive the ultimate recommendation because they are not evidence that California's existing antitrust laws are failing. And frankly, we find it troubling that the Commission cites the working group report as support for creating a new law. But at the same time, the Commission has rejected the working group's finding that this particular proposal should not be adopted. Selective reliance on the working group report puts the recommendation on shaky footing from a policy perspective as well as a legal one. Next, as you know, affordability remains a critical issue for Californians. This proposed bill, however, will only increase costs for businesses. Businesses will incur substantial costs in attempting to comply with what is an expansive and vague recommendation, which has no corollary in any other jurisdiction that could be a guide for businesses. For the same reason, litigation costs are also going to soar. And because the Commission has rejected any market power or market share thresholds on the application of this law, these increased costs, they will be borne by all businesses, both large and small. Now, the Commission has repeatedly said that it wants a passable bill. We agree, but this is not a passable bill, as I mentioned, I think, in the last hearing, because the text fails to give courts and businesses clear guidance on what is unlawful and what's not. We detailed these issues in our May 2025 public comment, as well as the January 2026 public comment. And as we all know, New York has gone down this road with similar proposals for the past 5 years, and they have repeatedly failed in a very progressive legislature. The Commission's proposed recommendation, in our view, is even more sweeping than New York's because it's not at all tethered to any existing antitrust law doctrine and expressly rejects certain aspects of federal antitrust law. Finally, staff's last-minute revision to subdivision C really is inexplicable in our view on at least 3 fronts. The first is staff says that the revision was made to address public comments critical of existing subdivision C, which, as you know, was itself a late addition to this process. But this revision, it doesn't at all address the substance of those public comments. It just rewords the subsection to accomplish the same goal, which is to prohibit California judges from being able to balance pro-competitive benefits in one market with anti-competitive harms in related markets. Second, it's not correct for staff to say that existing California law prohibits this kind of cross-market balancing. The Marsh case that staff cites in the memo says nothing of the sort. The court in that case did not at all analyze whether cross-marketing balancing is permitted under California law. In fact, the case doesn't even mention the concept. The flagship case that Ms. Johnson mentioned earlier this morning also does not analyze or even mention cross-market balancing. By adopting subdivision C, to be clear, you are not codifying existing California law. You are creating new California law. Third, the revision was suggested by staff just 3 days before this hearing. After public comment had closed, we know they've been under a lot of work and have been very busy, but a proposal that bars the judiciary from considering real-world effects from single firm conduct, it needs to be thoroughly vetted and reviewed by the public and all stakeholders, and we just haven't gotten that opportunity. We see no reason why you need to rush this proposal at today's meeting when you can, and in our view should, take the time until the March meeting to fully understand the consequences of what is a very substantive change. Thank you. Happy to answer any questions you might have.
Thank you, Mr. Henson. Any questions or comments from commission members? Seeing none. Thank you. Next presenter.
Megan Bill.
Hello. Thank you for taking up this important issue. I'm Megan Abel, Vice President of Advocacy at Tech Equity Action. Tech Equity is a research and policy advocacy organization focused on economic equity issues that result from the tech industry's products and practices. We work to ensure that the tech industry is held accountable for the harms that it creates in our communities and advocate for policy change to ensure that tech's evolution supports human flourishing rather than undermining it. First, I want to thank the commissioners and the staff for their excellent work in providing thoughtful and careful analysis on how we can ensure competition that fosters innovation and strengthens opportunities for workers and consumers. An innovative tech ecosystem that allows all companies to compete on the merits and build products that deliver widespread social benefits doesn't happen by accident. It happens when California's leaders have a clear vision for the future, one that centers improving everyday people's lives, solving intractable public problems, and spurring a great new generation of builders and dreamers. It happens when governments and regulators work hand in hand with the public to ensure that tech markets develop in the public's best interest, not in ways that entrench and grow our economic inequality. The recent AI boom is only deepening that power. Firms like Google, Microsoft, Amazon, Meta, and others control access to key inputs necessary for building the new tech ecosystem that AI will create. This means that instead of competing with big tech firms, AI startups are dependent on them for resources, for growth, and even survival, hampering the sprawling and innovative tech economy that is core to California's identity. This market reality is that the AI industry is not competitive. New entrants are able to enter the market, but they are dependent on the resources controlled by dominant firms in order to succeed, creating a tech ecosystem of dependence rather than competition. Lack of competitive pressure does not fuel innovation, it stalls it. We've worked in close partnership with many of the organizations speaking here today and would generally echo our partners' comments, specifically urging the Commission to adopt the recommendation before you today, which represents the sum of inputs of dozens of advocate comments and letters and careful staff preparation. We want you to move forward and vote on these recommendations since you've gone through such a lengthy and thorough process where all key stakeholders were involved. And we urge the Commission to consider who does a delay in finalizing these recommendations serve. The small business hoping to be competitive in a market where resources are further constrained into fewer and fewer hands, the workers who want more options and opportunities to find competitive wages, or do the large companies benefit who want to ensure that they can continue to engage in the status quo on antitrust matters, driving up prices, driving down wages, and buying up their competitors? The time to ensure our antitrust laws are robust is now. We thank you for your time.
Thank you. Are there questions or comments for this presenter? Seeing none, thank you so much. Next up.
Jennifer Suh.
Hi, I was actually wondering if I could give my slot to Greenlining Institute, Liza. I think she has a hard cutoff at 1:30, and I'll raise my hand again later.
Oh, that's very kind of you. Do we have? Yes? Okay, sure.
Liza Padel.
Hi, thank you, Jennifer, and thank you to the Commission for allowing this. Appreciate this. Hello, everyone. I'm here representing the Greenlining Institute. We are a nonprofit organization advocating for the economic opportunity and inclusion for communities of color and based in Oakland, California. I want to start by thanking the Commission for your extensive and transparent efforts over the last almost more than 2 years studying this need for Californians, and we support the recommendations being approved today. Anti-competitive behavior, we know, hurts all consumers, but especially I think what has been missing from this conversation is how much it hurts communities of color in particular, who are then further priced out of business and innovation and often left behind when a single firm has disproportionate power over any area. We've seen this before with telcos and digital divide, which is now becoming an AI divide, and also with food deserts. So we think it's a long overdue loophole that this recommendation will close and that allows for Californians to be more protected. So thank you.
Thank you. Any questions or comments for this presenter? Seeing none, thank you so much. And we back to Jennifer.
Jennifer Suh.
Hi, we applaud the Commission and staff for your commitment and hard work on this comprehensive study to update state law to address modern practices of anti-competitive conduct. My name is Jennifer Suh, and I'm speaking on behalf of the Writers Guild of America West, a labor union that represents more than 10,000 writers of movies, television, and streaming series in California's vital entertainment industry. The Writers Guild is here today to urge the Commission to formally adopt the tentative recommendation on single firm conduct and send the final recommendation to the state legislature. The Commission has diligently overseen an extensive study of single firm conduct over the past 3 years, which has included a working group report authored by several antitrust experts and over 100 public comment letters and statements. I believe that the Commission has done its due diligence to reach consensus, and the policy will continue to be refined in the legislative process. As we've detailed for the Commission before, our industry has seen vertically integrated giants like Amazon take advantage of their array of interconnected businesses that reaches across the value chain of entertainment to engage in harmful behaviors like demand shares of their advertising revenues and greater control over the competing platforms' viewership data. Without rules limiting anti-competitive behavior of a single firm, dominant companies have the power to disadvantage competitors across the entertainment industry and streaming ecosystem. We also oppose any edits to the tentative recommendation that would allow market harms to be offset by supposed benefits in a separate market, which could be used to justify almost any anti-competitive behavior, for instance, by claiming that labor market harms are offset by lower consumer prices. We support the current proposed revision to Section 16731 that does not introduce out-of-market balancing. We appreciate the opportunity to comment again on the subject of single firm conduct. The task of updating state antitrust law to serve today's markets is long overdue and urgently needed. We look forward to seeing the Commission forward its final recommendation on single firm conduct to the state legislature. Thank you for your time.
Thank you, Ms. Suh, and for allowing the lady ahead to not miss her appointment.
Thanks for allowing
any
that.
questions or comments? Any questions or comments for Ms. Suh? Seeing none, thank you.
Daniela Fernandez Yulin.
Thank you. Good afternoon. My name is Daniela Fernandez Yulin, and I'm speaking on behalf of Cameo Network, a national coalition of community-based small business organizations committed to advancing equitable access to capital, fair markets, and economic opportunity for California's smallest businesses, especially entrepreneurs of color, women, immigrants, and low-wealth communities. We strongly agree with comments regarding the Office of Healthcare Affordability and the need for strong oversight on healthcare mergers. This is not only a healthcare issue, it is a consolidation issue and a small business issue. 67% of small business owners who offer health coverage report that rising costs directly affect their ability to operate, hire, and retain workers. Increased consolidation in the healthcare sector reduces competition, raises prices, and places disproportionate strain on small employers. We also echo concerns about the rapid expansion of financial technology companies that are increasingly skirting California's truth in lending and consumer protection laws, creating real risks for small businesses that lack bargaining power or legal resources. According to Small Business Majority, a research and advocacy organization representing more than 20,000 very small business owners in California, there is a growing unlevel playing field between small and large companies. Under-regulated technology platforms, corporate consolidation, and harmful business practices are restricting markets and stifling competition, particularly for the smallest and most vulnerable businesses. An opinion poll of 500 small business owners found that 56% say one or more large companies dominate their industry, 56% agree that large companies have an unfair advantage in their line of work, 44% report an increase in monopolistic practices in recent years. 83% believe that large companies can take small businesses' creative ideas, mass produce them, and drown them out using market power. 82% agree that the economy is changing and it is time to update our laws for the modern age. Cameo Network urges the California Law Review Commission to move forward with its recommendations to continue strengthening oversight, transparency, and enforcement across healthcare, financial services, and technology sectors to ensure fair competition, affordability, and economic stability for California small businesses. Thank you for the opportunity to share our perspective.
Thank you. Any questions or comments for this presenter? Seeing none, thank you so much. Next up.
Amy Hines Shake.
Hello?
Yes.
Hi, Honorable Chair and members. My name is Amy Heinscheich with Wildcat Consulting, representing United Domestic Workers, AFSCME Local 3930, and their 225,000 care providers in the state of California. Your tentative recommendation on single firm conduct reflects what UDW and our care providers needed to see, and we encourage you to finally adopt the tentative recommendation as is. In particular, we approve of the recommendation that distinguishes California antitrust law from federal law, rejecting federal under-enforcement and under-deterrence, draws on existing language and best practices under federal and state antitrust law rather than creating a wholly new standard, recognizes the unique evidence of anti-competitive conduct by digital platform companies without creating an industry-specific approach, recognizes that unilateral restraints of trade can occur where a single firm possesses market power comparable to multi-firm restraints of trade, expressly prohibits illegal concentrations of corporate power that also harm wages, working conditions, and job mobility, codifies the prevailing standard under federal and state antitrust law against cross-market balancing, preserves core limiting principles like substantial foreclosure test for prohibiting exclusive dealing, and provides judicial guidance to clarify the reach of California antitrust law to include predatory pricing and anti-competitive refusals to deal. The Commission was charged with determining how to strengthen California's antitrust law amid a historic affordability crisis. What emerges in the tentative recommendation is a thorough approach to ensuring that the Cartwright Act is capable of addressing anti-competitive conduct as it occurs today. We acknowledge that there remain disagreements among those who have submitted comments to this commission, and we hope to resolve any remaining concerns over the legislative process. Thank you so much for your hard work on this matter and your professionalism and the professionalism of your esteemed staff. We respectfully urge your aye vote to adopt the recommendation as is. Thank you.
Thank you. Any questions or comments? Seeing none, thank you. Next up.
Peter Leroy Munoz.
Good afternoon. My name is Peter Leroy Munoz, and I'm here on behalf of the Bay Area Council. While we appreciate the Commission's intent to consider this important decision or issue, we are deeply concerned that the current proposal for single firm conduct will inadvertently stifle innovation, burden our state's small businesses, and ultimately harm the very consumers it seeks to protect. By lowering the dominance threshold, the Commission is signaling to California's most innovative firms that once they succeed in the market, they must stop competing aggressively. Specifically, by removing the federal recoupment requirement for predatory pricing, the Commission is making it legally hazardous for companies to offer deep discounts or low-cost bundles. In a digital economy, these are the primary tools used to disrupt stagnant markets. If companies cannot price aggressively without fear of a lawsuit, innovation in California will stall. By untethering California from established federal precedent, the Commission creates a vacuum of pricing uncertainty. Small businesses will face increased costs from their own suppliers who, fearing abuse of dominance claims, will likely end the volume discounts and efficient bundling that small businesses rely on to keep their own overhead low. We are also concerned about the abandonment of the consumer welfare standard here. For decades, antitrust law has focused on a simple question: does this conduct hurt the consumer? The proposal here shifts that focus toward protecting competitors. History shows that protecting specific competitors often leads to higher prices and fewer choices for families and consumers. Furthermore, the proposed prohibition on cross-market balancing means a court could find a company liable for an abuse in one sector while being legally forced to ignore the massive free benefits the same company provides to consumers in another. This is a fragmented view of how the modern economy works and does not reflect how Californians actually live and conduct business. We urge the Commission to reconsider these untethering provisions and maintain the consumer welfare standard as the primary lens for enforcement and raise the dominance threshold to a level that reflects true market power. Thank you.
Thank you. Any questions or comments for this presenter? Seeing none. Next up.
Angie Chua.
Hi there, can you hear me?
Yes.
Okay, great. Thank you to the Commission for the opportunity to share my story as a cautionary tale in hopes of adopting the staff's recommendations. I'm Angie Chua. I'm a small business owner and an artist at Bobo Design Studio, stationery company, and Bobo Palm Springs, a brick and mortar stationery store in Palm Springs, California. And I'm here to talk about my experience and the concerns of many small businesses whose websites were scraped without our consent to create storefronts on Amazon using our brand names. In December of 2025, I noticed some weird shopping activity on my site, which I initially thought were scammers testing credit cards. But then it turned out these random orders were actually coming from Amazon in a program that we now know as Buy For Me. As a business, we have always chosen not to list our products on their platform or leverage any third-party sellers to list our products on their site. So imagine my surprise when I discovered that part of, if not my entire product catalog, was listed on Amazon under their Buy For Me program. After sharing my concerns on social media, it uncovered that literally thousands of small businesses had seen their entire catalogs put on Amazon without their consent or knowledge. They'd scraped our entire sites from Shopify, as well as WooCommerce, BigCommerce, and Squarespace. They proceeded to take our product listings and photos and create duplicate listings of our goods on their site. These listings used AI images that weren't ours and even included products that don't exist in our backend anymore and were deleted long ago. The product names and descriptions were slightly altered on Amazon sites, probably to manipulate SEO and make our products compete against ourselves on Amazon, which again, a platform that we have never done business with in any shape or form. When I tried to get our products taken down, they told me we could opt out of this program that we never signed up for in the first place. Amazon even suggested that they were doing a benefit to these brands, allowing them to be on their global platform. If this was such a beneficial program, why not reach out to us and invite us to join? Why must it have been done without any party being alerted? Their unchecked use of AI scraping our sites and creating fake products and listings that don't reflect the hard work we put into curating our brand and products is harmful. There are many unintended consequences from all of this, and both tangible and intangible costs add up quickly for a small business. The obvious ones are product itself. When an order got placed through the Buy For Me program, what the consumer saw on Amazon might not match what the stores were seeing on their back end. And as a result of their sloppy and unchecked use of AI, we were shipping wrong items, which means lost money on product, potential chargebacks, shipping costs, credit card fees, and that does not even include the customer service nightmare that follows, eating up our time and labor. They were selling items of ours that were completely out of stock, adding to our customer service headaches. We then have to email these customers back, but who knows if they're getting these emails since Amazon scrambles the emails of the customers when we see them. The biggest issue here is trust. As a small business, we invest a lot of time building trust with the community to earn their business. The lifetime value of a customer comes from us building a relationship through those emails. But when Amazon swoops in, hiding their emails from us, Amazon ends up owning that customer relationship, even if that customer was looking for us by name. We lose the chance to recapture that customer and build that direct relationship with them. And to say it succinctly, they are literally stealing customers away from us. Amazon's scraping and reselling practices totally undermine the basic principles of fair business and competition. Business deals should involve mutual consent and not be imposed secretly by a big player. We know Amazon doesn't do this out of the kindness of their heart. They're after the valuable data from the sites of literally thousands of brands who refuse to list their goods on Amazon. To be exploited and forced into a program by this tech giant without our consent or knowledge is a clear and massive overreach on Amazon's part, and this is not new behavior for them. I hope that my story illustrates the unchecked power and monopolistic behavior in big tech and commerce and how they negatively impact small businesses like mine, and that the Commission adopt the staff's recommendations. Thank you for your time.
Thank you. And honestly, I'd never heard of this scraping before, so thank you. Any questions or comments for this presenter? Seeing none, thank you. Next up.
Lee Hepner.
Hello and good afternoon, commissioners. My name is Lee Hepner. I am senior legal counsel and an antitrust attorney with the American Economic Liberties Project. I want to commend the CLRC's study and what is truly a consensus approach following 3 years of research well over 100 letters received by this commission. It is a proposal that I believe resolves uncertainty by narrowing the application of ambiguous standards that have really undermined the rule of law for many decades. While I support this proposal, I want to be clear that it is not a wish list. I believe it is a modest step forward. There are many things that were requested over the past 3 years that the commission staff and working group and the commission itself have rejected. We did not get an abuse of dominance standard. That was, in fact, the New York proposal that failed that Mr. Ensign mentioned earlier. We did not elicit a requirement for all antitrust complaints to be finally adjudicated within 2 years, as some matters trail on for 5 or more years. We did not elicit more rigorous standards with regard to remedying an illegal monopoly. And we have seen recent cases federally where liability was found, but the court failed to terminate an illegal monopoly or force divestiture of ill-gotten gains. So I respect that the CLRC staff has provided an amendment to the section on out-of-market balancing. And I think that is yet another concession. I will go out on a limb and say that I think it is a concession that I can personally support. Once again, this commission is being advised to craft a balance. But I do want to explain why limits on out-of-market balancing are critical. Out-of-market balancing would allow courts to allow for monopoly power to accrue if it creates benefits in marketplaces far outside of the monopolized market. And for well over a century, courts have not allowed this. Only in the past decade have courts begun to erode that long-standing aversion to out-of-market balancing. In one recent case alleging that Google had illegally maintained a monopoly through various anti-competitive conduct in search engines, other search engines who sought to compete, who sought to innovate, who provided search engines that advertised environmental benefits or greater privacy protections were unable to compete because Google had secured exclusive deals with every browser, every smartphone, every wireless carrier to box them out of market access. Now, when the remedy came, the court refused to terminate Google's monopoly, where it had illegally maintained a 90% market share, because it had funded the development of web browsers and subsidized Apple iPhones. So, Google had effectively structured this entire technology market far outside of search engines. And so competition in a market that controls the flow of information across our society was decimated by supposed benefits to completely unrelated technologies. It is not hard to see how this invites a slippery slope that threatens to eviscerate the law altogether. It is tantamount to saying that a company can destroy grocery stores so long as they fund a car dealership. I believe that allowing out-of-market balancing creates more uncertainty, but that uncertainty accrues to the consumers, workers, and small business competitors who are harmed by monopoly power. In conclusion, I think this is just one piece of the CLRC's work. I believe it strikes a balance informed by advocates and experts across the spectrum of this complex issue area. And the CLRC and its staff have done a commendable job at crafting a proposal that reflects well understood federal standards while fortifying their applicability under California law. Thank you so much.
Thank you. Any questions or comments for Mr. Hepner? Seeing none, thank you. Next up.
Bianca Blomquist.
Hi there. Good afternoon. I have my testimony and I have a testimony from a small business owner, if I may read them separately.
Okay.
Thank you. The first is from a small business owner named Ted Milner. Honorable members of the commission, I speak with you today as a small business owner of over 40 years who's been fighting against the rising tide of big money and monopolistic practices in the entertainment contracting space. We specialize in providing temporary, temp to hire, and permanent staffing solutions, likely focusing on administrative or executive support roles for corporate clients. My name is Ted, and my story is a testament to the challenges that small businesses face when trying to compete with large corporations. In the past, the entertainment industry relied on outside agencies, but over time, Apple One, for example, has become the primary agent on site at NBC Universal. They forced us to use their services at 3 times the price of independent vendors for background checks, for example, and then took a percentage of our income on top of those fees. When I challenged them, they didn't just lose business, they got verbally violent with me. Let me be clear from the start. big business does not drive the economy. Small businesses do. Small business owners employ roughly half of America's private sector workforce, fuel innovation, and keep industries competitive. Today, large corporations grow by absorbing, outsourcing to, or squeezing the very small businesses that do the real work. And this is not about punishing companies for being big. It's about stopping them from using their size to stifle innovation, eliminate competition, and extract value without accountability. In the past, our industry relied on competitive outsourcing. Independent vendors thrived because we were efficient, creative, and responsive. This is innovation. That changed when Apple One became the primary agency on site. I was forced to use their services, and while they took percentages of our income, they lost my business, but intimidation continued to follow. That wasn't competition. That's control. Today, that same control is exercised through technology. Companies like SAP Ariba dominate procurement systems so completely that small business owners have no practical alternative. We're forced to pay thousands of dollars, give up additional percentages of our earnings, and then blamed when payments are delayed or lost inside systems designed without us in mind. Corporations like Disney then hide behind these platforms to justify late payments to minority vendors. I've provided proof. I've documented the failures. The response is always the same. There's nothing we can do. It's the system. But they chose the system, and they benefit from it. At the same time, these corporations promote minority and small business programs that are so expensive, complicated, and restrictive that participation becomes nearly impossible. That's not support, it's a barrier dressed up as a press release. Small businesses are where innovation actually happens. We move fast, we experiment, we solve problems before committees are formed, we train workers, create new methods, and adapt in real time. When monopolistic practices push small businesses out, innovation doesn't scale, it dies. And this is bigger than my story. It's about the 4.2 million small business owners in California being squeezed not because they failed, but because access to the market is controlled by a few powerful players. So what needs to happen? First, we must level the playing field so small businesses can compete based on ideas, quality, and efficiency, not on who can afford the biggest fees or survive the longest payment delays. Second, corporations must be held accountable when they use software platforms and bureaucracy as shields against responsibility, especially when minority vendors are disproportionately harmed. And finally, we must recognize the fundamental truth that small businesses are not dependent on the economy. The economy is dependent on small businesses. We're not asking for favors. We're not asking for fairness. We are asking for the opportunity to compete. Thank you, and I urge you to move forward with the recommendations. I'd
Okay,
also
and then your comments now, right?
I have two more small business owners that would like to share their brief remarks with the
Okay. Brief would
Rachel.
be good.
Thank you so much. Rachel Klein is the CEO of Firestarter Studios, a Santa Clarita-based entertainment company with 2 full-time employees that scales to more than 300 workers annually during production. She wants to keep creating jobs in California, but says the rising cost of operating a small business here makes it that increasingly difficult. But it may not be for the reasons larger business interests may have you believe. Rachel explained monopolies are already highly regulated, yet mergers and acquisitions continue to consolidate control over production, distribution, and financing into fewer companies like Amazon and Netflix. As a result, entire local ecosystems like Los Angeles are being hollowed out. Unquote. Rachel believes there is enough room in the industry for everyone to succeed, but fears that unchecked consolidation will lead to monopoly or duopoly that controls the entire pipeline, squeezing out independent studios before they are given a real chance to grow and innovate. She urges you to move forward with the recommendations before you today.
Thank you.
JB, thank you. JB Herrera is the CEO of Synergy AI, a small technology firm based in Sacramento, California, with 2 employees and a few contractor developers. After spending his entire career in technology, JB saw firsthand how companies start out scrappy, innovative, but he notes different rules apply once companies reach scale. Between big and small, big is not playing by the rules. As a small business owner, he now experiences the imbalance from the other side. He explained to me that, quote, policies meant to support growth often continue to benefit dominant firms long after they've gained market power, creating structural barriers for smaller competitors, unquote. JB would like the California Law Review Commission and members of the public to know that small business owners are not seeking ownership or special access. Rather, they are asking for a fair marketplace where innovation and survival are not undermined by single firm conduct that advantages size over merit. May I move forward with my testimony?
Yes.
Thank you. My name is Bianca Blomquist. I've been speaking today to highlight the challenges faced by the small business owners in our network in various sectors, particularly those dominated by large corporations. I'd first like to flag that Small Business Majority has been doing this work since 2005, and each of the small business perspectives I've shared with you over the past 2.5 years have been part of our network for years and in some cases decades. Responding briefly to an earlier comment, what should drive, at very least in part, the Commissioner's work at this time is the feedback from the dozens of small business owners who took time from their place of business to share their concerns with this Commission and members of the public. I have had few, in fact, no conversations with business owners who don't see value in balancing anti-competitive behaviors that we all see every single day. Take a look at the Better Business Bureau for some insights as to how bundling, for example, is working for everyday small business owners. The experiences of small business owners that have implored the Commission over the past 2.5 years, like Executive Temps in Burbank, Savannah Williams from Digital Media Services, Visual Terrain in Santa Clarita, Wit and Whimsy Toys in Granite Bay, International Metal Source in Buena Park, illustrate the difficulties that small business owners face dealing with anti-competitive practices. As Ted Milner, CEO of Executive Temps, noted, curbing anti-competitive practices can help level the playing field for small businesses to compete on merit rather than scale. In other industries, such as lighting design, companies like Visual Terrain struggle with pay when paid clauses that allow big firms to withhold payments from them until their clients have paid in full. Savannah Williams of Digital Media Services spoke about the unfair advantages that large corporations receive due to their size and scale. She said her business is forced to use the same platforms as multi-million-dollar corporations who are sometimes competing with her business, facing the same rules and fees without any benefits from volume or scale. We urge you to recognize the broader community impact of consolidation, take steps to protect local jobs created by small business owners, preserve opportunity for small business owners, and ensure that small business owners have a voice in markets that shape their future. We urge you to move forward with these recommendations, and I thank you for being gracious with your time.
Okay, thank you. How many presenters do we have left? 4? Okay. Next presenter, please. I'm sorry, were there any questions or comments for? No, okay. All right. Next presenter, please.
Lucine Chikezian.
Good afternoon, Lucy Chinkezian on behalf of the Civil Justice Association of California. Our membership base consists of businesses and associations from a broad cross-section of California industries. We are strongly opposed to the final recommendation on single firm conduct being voted on today and urge the Commission not to rush in approving them. Thank you.
Thank you. Any questions or comments here? Seeing none, thank you. Next presenter, please.
Devin Gray.
All right.
Good afternoon, everyone. My name is Devin Gray. I'm the president of an organization called End Poverty in California. I just want to thank everyone and the staff for just what's been an immense amount of work over the last year or two. It's a Herculean effort to go through all of this, and it's not gone unnoticed. Also want to echo the sentiments of so many others who have commented by urging the Commission to adopt the proposed single firm conduct recommendations. I want to spend my very brief time, and I promise I'll be brief, talking about just what regular people around the state see and feel in the economy. Our organization spends considerable time up and down California and convening folks who are low income and struggling to get by. And regardless of geography, there really is an overwhelming and I would say justified perception that the economy is rigged against people, and that corporate concentration in particular has harmed low income communities in the aggregate by harming workers and consumers, and specifically by making it harder for small businesses to thrive. And further, it is clear to us that there is a tremendous amount of popular will and support among Californians in every region, coastal, inland, northern, southern, in between, in favor of reforming our antitrust framework. So I think we have an incredible opportunity here to be responsive to what Californians are calling for to separate ourselves from the example that's been set by the federal government and make our state one where working people can succeed. So I just want to thank everyone here for putting our state on a path towards making our economy fairer and more competitive and enabling us to better address the many crises facing Californians today. Thank you.
Okay, thank you. Any questions or comments for this presenter? Seeing none. Next up.
Robert Hurrell.
Hi, good afternoon. My name is Robert Hurrell. I'm the Executive Director of the Consumer Federation of California. We're a statewide organization that works on a wide range of consumer protection and issues. First of all, I have 3 points I'd like to make, and I'll try to make them briefly. I know you've been hearing a lot of comments, and thankfully, it sounds like you're nearing the end of the comments. First of all, I'd like to profoundly thank Chair Simpson, all the commissioners, and the staff and the experts that have participated in this lengthy process. You have done really thorough and comprehensive work in this space. It is to be applauded, and I know it has taken a lot of work and effort and back and forth. And we appreciate all of us. Certainly, I would think no matter where we think about the final product, would appreciate profoundly the work that's gone into this. Secondly, I'd like to urge support of the finalizing of the tentative recommendation, which is before you today. By doing so, you would be profoundly supporting or showing your support of small businesses like the ones you've heard from today, and you would be profoundly supporting the championing of innovation itself. The recommendations before the commission actually enhance innovation. No matter what some opponents may want to say, that would be the action that you would be taking to refer it to the legislature and begin that process. Finally, I would just note that monopolists, oligopolists, and their apologists want the status quo. Why? Because it's working extremely well for them. In fact, it's working so well, you have to go back more than a century to see when it hasn't worked quite so well for them. But we must step forward, and California must join the 45 other states that allow for individual laws against illegal monopolization and the profoundly negative impacts that they have on consumers, workers, small businesses, and our communities. Thank you very much for your time.
Thank you, Mr. Hurrell. Any questions or comments? Seeing none. Is that the last one? One more.
Donnie Tedeschi.
Good afternoon, Chair Simpson and commissioners. My name is Donnie Tedeschi. I'm here representing Rise Economy. We're a member-led alliance of over 300 nonprofit organizations throughout the state dedicated to combating the legacy of redlining in communities of color by pushing back on the excesses of consolidation in the financial services industry and holding banks accountable for their role in creating community-centered economies. First, I'd like to thank the CLRC and its staff for the extraordinarily diligent and in-depth work they've done over the course of this process. We deeply appreciate the Commission's and the staff's excellent work on this complex issue and applaud the Commission on nearing the conclusion of its extensive study of California antitrust law. Our organization works primarily on issues of economic and racial justice in the financial sector, including the impact of bank consolidation and excessive market power on low-income communities and communities of color. While the tentative recommendations on single firm conduct focus significantly on large technology companies and other dominant firms, we strongly support its adoption because the underlying dynamics it addresses, concentration, under-enforcement, and the erosion of competitive constraints, are not unique to any one industry. Across markets, prolonged under-deterrence of anti-competitive conduct has contributed to higher prices, fewer choices, suppressed wages, and reduced access to essential goods and services. These harms fall disproportionately on workers, small businesses, and communities that already face structural inequities. From our perspective, the Commission's tentative recommendation represents a critical step toward restoring antitrust law as a meaningful tool to check excessive corporate power and promote fair, inclusive economic outcomes. We applaud the Commission's extensive work in capturing a broad scope of input from trade groups, businesses, advocacy organizations, and interested members of the public when forming these tentative recommendations. We now encourage you to finally adopt the tentative recommendations as is and pass the torch to the legislature for future consideration. Thank you.
Thank you. Any questions or comments for this presenter? Seeing none, thank you so much. All right, we've had a robust public comment session. I think the first thing we need to do is, do we want to adopt the modification to subdivision something of
So
something?
there's a few,
Okay.
let me go back to the point that Commissioner Carrillo
Oh, yeah.
made about section 16730
D.
D.
Yes.
And thank you very much for catching that. We went back and reviewed things and it should say this section, not section 16730. So we will make that correction
Okay.
everywhere it appears, right, Sarah? Okay.
Good. Thank you. Any
So-
any concerns about that?
No.
Okay, we'll
Thank
do
you.
that.
And so we had recommended changes in the main memo and the first supplement.
Yes.
So,
And
so the question would be, does the commission wish to approve the draft final recommendation as proposed to be revised by those two memos and with this additional technical change that the commission identified?
correct. So do we, is this,
Commissioner Carrillo has a question.
I'm sorry.
Yeah, Rick, whenever you call for discussion, I had a brief point to make.
Yeah. No, I went, so yeah, before we take a vote, we want to have discussion. So, Carrillo, you want to go first?
Sure, as long as I have the floor. I just wanted to mention, while I was listening to the public comment, I was also looking up the case Marsh versus Anesthesia Services, 200 Calap 4th 480 that one of the commenters mentioned. And the question was whether the court in that case talked about defining the relevant market and applying the rule of reason. And the court spends about 4 or 5 pages doing exactly that. So maybe I misheard the public comment, but I read it exactly the way the staff does. It's pretty clear.
Got it. Thank you. Any other, what other comments by commissioners or thoughts or?
Mr. Chair,
Commissioner Huebner?
I listened very closely, as always, to the public comment and have been through the papers. I'd like to commend staff and our consultant for the excellent work. And I would support moving the proposal forward.
I would second that.
Okay, I would say that constitutes a motion and a second. Is there
And
any?
that is to
Include the-
adopting the staff recommendations and the technical change that was identified.
Right, the modifications in the main memorandum and the modifications about separate market issues in the first supplement, correct? Okay.
Ambassador?
That was my intention, yes. Thank you for
Okay.
clarifying.
And that's what I understood when I seconded it.
There you go. Any comments, discussion from commission members? We've heard about this quite a bit and had some quite robust public comment. Sounds like we are ready to make a decision.
Should I call the roll?
Why don't you call the roll?
Okay. Commissioner B?
Aye.
Commissioner Carrillo?
Aye.
Commissioner Kuba?
Aye.
Commissioner Huebner?
Aye.
Commissioner Jenkins is no longer present. Commissioner King?
Aye.
And Commissioner Simpson?
Aye. Ayes 6, noes none. The recommendation, the final recommendation on single firm conduct is approved. Okay, It's been a long, what, 3 years, 2.5 years? Um, Thank you all. Our next, no, that's all for today's
That's all for
meeting.
today.
Okay. And our next meeting, I don't have a copy of the schedule in front of me, but is
March 20th, right,
March-
Sarah? Yes.
March 20th. And we will be revisiting mergers and acquisitions, I presume?
Yes.
Okay.
Sorry, my mic was off. Yes, we plan on
Okay.
revisiting mergers and acquisitions at the March meeting.
Okay. I wish all of you a relaxed weekend.
Thank you so much.
Thank you to everybody and to all the folks both here and online for sharing thoughts and recommendations. And we will see many of you again in March.
And thank you to our chair for skillfully moving us through very complex agenda over the last several meetings.
Oh,
Thank you.
Thank you. That's very, very kind. Okay. And it's not even school finance, so what are you gonna do? I still don't know much about Rich, though. Yeah, right. Okay, thank you all, and we are adjourned.